And the first one is by Professor Marc-Andre Renold from Geneva. Professor Renold is director of the famous Center for Art and Law in Geneva, the University of Geneva. I think it's one of the biggest centers for art and law globally. So you may know all different summer schools that Professor organizes, and excellent conferences this year in June.
Yep.
In June. So I think it's still possible to register to
Absolutely.
Absolutely. So and summer school this year is any summer school this year?
Yes, the last week of June and 1st of July.
Okay, so if you're interested, please consult the website of the center to get to know more about these initiatives. And Professor Renold generously agreed to present this different perspective on the directive because it's from Switzerland, which is not part of the EU, but obviously is the second biggest market, art market in Europe, and we are we are looking forward for your comments about this extraterritorial operating of directive.
Thank you, Andre. Thank you very much for this very warm welcome here in Warsaw. So here I just put my USB key so that you sort of see that if Jim yesterday said that he felt a little bit like a fraud, well, I feel doubly like a fraud because here we are in Switzerland, surrounded by the EU, and but we are not members. So this explains why I still wanted to stay in touch with the topic, but wanted to talk about the possible extraterritorial effect of the directive. So what is extraterritoriality? Well, this brings me back many, many years because actually my PhD was on extraterritoriality, but not of cultural property law, but of economic legislation. And at the time, I thought very, very long on that topic. But I'm not going to say too much about it. But there's basically two ways to see things. There's the direct extraterritoriality and indirect. Direct is when a state or a group of states tries to enforce its legislation abroad, or at least to influence the acts of people abroad. The famous cases are those linked to United States law when the US attempts to affect acts of foreign companies abroad. And that happens in antitrust law. Now, more to link to the topic today is perhaps the indirect extraterritoriality. It's when there is a certain legislation and it so happens that it has an effect abroad. And that's a little bit what I'm going to see with you now. There's two types of effects, I think. A direct one and an indirect one. The direct effect of the directive in Switzerland, we can see in three types of cases. When a cultural object will be brought to Switzerland, there will be some effect. Then when we have a transaction, perhaps in Switzerland, but that is subject to the law of an EU member state. And then there will be specific private international law issues, which I will quickly deal with on the third step. And then you have, this is probably which is the closest effect that the directive actually has in Switzerland. And the indirect effect is, how does it actually, is it being taken into consideration in legislation? And one case is EU law in Switzerland. And secondly, I will finish with what you might call international public policy. Now, first, the first set, direct effect. If you have a transfer in Switzerland of a cultural object from the EU, that's pretty obvious. When it's exported from the EU, it must respect the rules of national legislations implementing the directive, so all the legislations that we heard of today, in that respect will have some effect, as well, of course, as the EU regulation of cultural objects. That's, of course, when it leaves the EU. When it comes into Switzerland, well, that's a little bit more tricky, because our legislation requires that to be considered illicitly imported, an object has to fall into or fall under a bilateral agreement that Switzerland has or might have ratified. So we've ratified 6 up to now, 3 with EU member states, Italy, Greece, and Cyprus. So that's the first step. If there is a bilateral agreement, then we will have an illicit import if the legislation of the EU has not been respected, and then it's going to be returned following the agreement or following the International Transfer of Cultural Property Act of Switzerland. So that's the first step, and I'm sure we all agree it's relatively straightforward. The second step is if we have a transaction subject to the law of an EU member. And I have an example here taken from the lava treasure, which was a fantastic treasure of coins that was found in Corsica, off the coast of Corsica, by people who were looking for sea urchins, and they actually found, I think, more than 15,000 Roman gold coins. So this is typically a case. You would have a French or an archaeological object subject to French law, which is brought to Switzerland and sold at auction in Switzerland. Well, in such case, the EU legislation will affect the legitimacy of the sale. In this particular case, it will be the French statute, because there's actually no EU legislation on illicit excavations. So that's the first step. Now, if the transfer took place in France, right? If it was sold at, let's say, a private dealer who then brings it to Switzerland, then the standards of the directive would be applicable, including the well-known burden of proof that you've all heard about today and yesterday. If the transfer took place in Switzerland, then we will apply Swiss law, and we'll still remain within the classical burden of proof system of civil code systems with the presumption of good faith and no shifting of the burden of proof. So that's when you have a transaction that is linked to an object brought into Switzerland. Third indirect effect is when you might envisage taking foreign public law into consideration. If I take the same example of the illicit underwater excavation in Corsica, and it's sold under Swiss law. So normally, Swiss law would apply. However, we have exceptions that you also know in some EU law, like the EU Rome Convention on the law applicable to contracts. And the question here is, might we not exceptionally take into consideration the not normally applicable law? So the normally applicable law is Swiss law, but perhaps there are ways to take into consideration the foreign legislation, because it is imperative, because it furthers the same goals as Swiss law. And that's what our 1989 Private International Law Act states, that under exceptional circumstances, we can apply foreign imperative rules if if legitimate interests require it. So that's the whole debate. What are legitimate interests? And the protection of cultural heritage, the fight against the illicit trade, I would assume, or definitely I would plead it with pleasure in court, is a legitimate interest. Now, we don't have any particular precedents for now, although I'm going to talk to you about a case which is the closest we got to this. And this is the Mogul gold coin case. It's a bit, I'm sorry for those of you who have already listened to me, because you will know this because I talk about it quite often. It's a Supreme Court decision now a bit more than 10 years old, and it related to fantastic gold coins minted in Lahore, but a part of the cultural heritage of Hyderabad. And these coins were actually not just small coins, they were huge coins. This one was 11 kilograms, so, you know, big. And dating of the 16th century by Jehangir. And so, very interestingly, beautifully minted. What happened? This, what you see here, is the catalog of an auction, because the owner, who was the descendant of the Nizam of Hyderabad, he tried to first sell these at auction in Switzerland, and he was, well, he wanted too much, so the reserve price was not reached, so it was not sold. But he still needed money. So what does he do? He secures a loan with a bank. And as a guarantee for the loan, he gives the two coins. There was one like this one and another one a bit smaller. And receives 20 million, well, about 15 million euros loan for this. The problem is he lived in Australia. It's not a problem in itself. But he did not pay the interest or reimburse the loan. So after a while, the bank got upset and decided to use the guarantee. So sell the two coins. And that's when India steps in. India says, hey, wait a minute. This was illicitly brought out of India, and therefore it should go back to India. So this is a little bit out of our EU discussions, but never mind. It's just interesting for the discussion. So, 3 questions. The first question is, was the bank in good faith when it created the security? Well, classically, the court says yes. Good faith, first of all, is presumed. There is a higher degree of diligence requested from banks in this particular case, but also in the antiquities market. But the bank had been extremely careful, and it had, I mean, 2 bankers had actually flown to Australia, gosh, I wish I could do that, for business to check that the person was, you know, the right person to do this loan to. So that was settled. Second question, was there an illicit export from India to Switzerland? Well, that was very complicated, because the issue was actually that the owner was the descendant of the Nizam of Hyderabad. So he was actually, he had inherited that. When India was created, Hyderabad gave out a lot of its sovereignty, but a certain number of personal items, such as these personal small coins, were kept as property for the Nizam himself. So whether there was an export was very illicit export according to Indian law was a problem. In any event, and that is where I am very upset, because the Supreme Court says something that I am not happy with at all. It says that foreign public law will not as such be applied in Swiss courts. Why in the world did it say that? I don't know, because our Swiss Private International Law Act says exactly the opposite. It says a foreign public statute can be applied. So, you know, it's the Supreme Court, it's not perfect, and I'm just waiting for the next precedent so that we can change this. Third point, and that's where we come to maybe what is interesting for us. How was the loan itself valid, the security agreement? Well, that was subject to Swiss law, because it was a Swiss bank making the loan, so it was, Swiss law was applicable, and the court looks at whether there should be an exception under Article 19, perhaps applying Indian law. It rejected that, saying that the conditions of such an exception were not satisfied in the particular case. Now remember, this was in 2005. In 2005, the international conventions we're talking about, UNESCO, had not been ratified yet by Switzerland, because the facts were much before. The UNIDROIT Convention had not been ratified, and still isn't, by Switzerland, and there were no particular bilateral agreements. So in that particular case, the court says no. But the door is open for many possible potential issues. So all of this to say, there is this possibility that under Swiss law, we might apply European member state law even to a contract subject to Swiss law. Okay. Now, indirect effect. First of all, the role of EU law in Swiss lawmaking process. Every statute that is adopted in Switzerland is double-checked for its Euro compatibility. So when we adopt legislation at the federal level, we always check whether it's compatible or not. On certain cases, we say, too bad, it's not compatible, but we're still doing it because we're Swiss. And in other cases, we adapt so that there's no conflict. For the Swiss legislation on this particular topic, the International Transfer of Cultural Property Act of 2003, which entered in effect in 2005, well, the EU legislation, EU Directive at the time, as well as the UNIDROIT Convention, influenced the legislator. The legislator adopted shifting of the burden of proof for illicitly imported cultural objects. It extended the statute of limitations. So we did things that show a clear influence on Swiss law of the EU legislation. And finally, what about international public policy? Now, maybe that sounds like a vague concept. However, it can be of use, I think, in our field. First of all, the old Nigerian statuettes case of the German Supreme Court in 1972, where the German Supreme Court took into consideration the Nigerian law regarding illicit export. Okay, that's a relatively old case, but still it's interesting because it shows that the courts can take into consideration conventions that are not even in effect. The UNESCO convention at the time had been adopted, but was still absolutely not ratified by Germany. If we come a bit closer to now, the UK in Iran versus Barakat, a very famous case, accepted the application of Iranian law on the protection of cultural treasures that had been illicitly excavated in the area of Jiroft. To do that, several issues were discussed, but one of them was, well, in fact, we should take into consideration foreign public law because it's now part of the deal. It's part of the general landscape of cultural property law. If I recall correctly, the directive is quoted as one of the elements showing that states are now much more concerned about the fight against the illicit trade. And then we have the third item is international judicial cooperation. Now, in criminal matters. This is something that we have not dealt very much here, but I believe that it is a very interesting topic. There are certain European conventions on judicial cooperation, and you can actually use them to obtain the restitution of cultural property. You can use them because you can say that the cultural property is actually proof, evidence of an illicit activity, or you can even have the return ordered for the reason that it is the product of a crime. And so you actually use that. In this particular case here, a 1997 Supreme Court decision, which I much prefer than the other one. In this case, the court accepted restitution to France, or to the French court, which was requesting it, of a stolen old master that had been stolen in a chateau in France, based on the judicial cooperation, even though the possessor said that he was in good faith. So that's very interesting. And why am I quoting it here? Because the Supreme Court says there is in the field of cultural heritage an international public policy showed by the adoption of conventions, showed by the UNIDROIT Convention, even though Switzerland had not ratified it. Nevertheless, these documents are quoted as showing that there is this international public policy. So I think it's a very interesting precedent, and there will probably be more coming. So this is it. So the answer, what is the extraterritoriality as applied to cultural property? I think we can say there is one. There is a particular role played by foreign legislation, by EU law in Switzerland, mainly indirect extraterritoriality. And with that, I finish. Thank you for your attention.